Today we're going to look at the East African Court of Justice and what they do. Joining me in the studio to look at that is Professor Dr. John Ruhagisa, a registrar in the East African Court of Justice. You're most welcome to UBC.
My pleasure.
My name is Michael and this is UBC News Journal. Now, briefly, could you please tell us about the East African Court of Justice? The Ugandan watching out there would love to know exactly what is all about this court.
Yeah, the East African Court of Justice is one of the organs of the community. The community has mainly the operational organs are three. You have the Secretariat, the Court of Justice, and the Legislative Assembly.
Okay.
But on structure, there are more than three organs. You have the summit on top, you have the Council of Ministers, you have the Coordination Committee, you have the Secretariat, you have the Court of Justice, you have East African Legislative Assembly. So among those three, those 9 organs of the community, the East African Court of Justice is one of those organs of the community, and its function basically is to play the judicial role. When you look at the structure of the community as it is, in any active relationship, we expect disputes, misunderstandings, disagreements are bound to happen. Should they happen, now so the founding fathers.
That is the role of this court.
Yes, the judicial function.
Okay.
Yes.
Now, where does this court sit, first of all?
The court presently is sitting in Arusha. We call this the temporary seat of the court because under the treaty, the summit is supposed to nominate or to appoint a specific place where the court should sit permanently. It has not done so far. So it's an Arusha on temporary basis.
Now, what kind of cases does the East African Court of Justice handle? Just for starters as we begin.
Yes, the East African Court of Justice, as a judicial organ of the community, is charged with the responsibility to determine issues or disputes or cases arising out of the treaty for the establishment of East African Community, which is, the treaty contains areas of cooperation. So any dispute arising out of that particular area of cooperation is the mandate of the East African Court of Justice.
Anything that goes extra the treaty of the cooperation is already illegal.
Where as far as the jurisdiction of the court is concerned, it cannot entertain anything outside the treaty. Anybody who wants to bring the matter to the East African Court of Justice has to find a location in the treaty, and by the treaty I mean protocols which are an integral part of the treaty and the other annexes and the community law.
So I don't we've had politicians who say we are going to take our government to, in Kenya, Uganda, opposition politicians in various countries in the community. We've had them claiming they will take their governments to the East African Court of Justice. Can't the court, does that court handle such cases as well?
Yes, it can and it has. Heard several times those kinds of cases.
Do we have any precedents?
Yes, we have several precedents. For example, in the case of Uganda, you will remember the Katabazi case where it happened. Unfortunately, a group of about 21 people were arrested, charged in court-martial, and denied as terrorists, and they denied bail, denied the representation. They went to the High Court. The High Court said, no, these are civilians, should be, their cases should be heard by the civilian courts, not the High Court. But still the government did not heed to. They went to the Constitutional Court, which is Court of Appeal, upheld the decision of the High Court. Still nothing, was taken seriously. Now somebody became wise, especially after they had invaded the High Court. The security personnel invaded the High Court.
So it was finalized with the...
Finally, it was now referred to the East African Court of Justice. For one major reason. The approach that they used, who approached the East African Court of Justice, was that this is contrary to governance.
So, Professor, why I asked you that, I wanted to know that to differentiate the cases that are taken to that court. So it looks like, in what you've told me, it's not only cases that are in line of the state's cooperation that are taken to, but even other cases as far as the community is concerned can be handled in
Absolutely, because this community is the people-centered and the private sector driven. So civilians have a role in the integration. This is not the community for the partner states, it is the community for the people and the beneficiaries of this integration. When they look at the treaty and the conduct of a partner state and satisfy themselves that this is contrary to the agreement of my country in joining this community, they can still bring the matter to the East African Court of Justice. Just for example, issues of governance, rule of law, democracy, and human rights related issues. We have several cases which we have heard as a court.
Now, what are you people doing in Uganda as we speak? Because you even had a story yesterday, but one, that the East African Court of Justice will be in Uganda. Yes. We had a story yesterday, even today. What are you people doing here in Kampala?
We are here indeed in Kampala to meet our stakeholders, the users of the court. These are the stakeholders we are talking about. To know, we want their feedback to tell us how much have we been faring in terms of saving them as far as integration is concerned. And our main stakeholders we have come here to meet are the civil society, who have a big role, even acknowledged by the treaty. We are meeting the judges of the national judiciaries. These are also stakeholders because they are required under the treaty. When they come across a matter related to the interpretation of the treaty or community law, to refer this particular matter to our court for interpretation. And after the court has interpreted and determined, refers it back to a national court for continuation. That is the area we need to emphasize on our national Uganda national courts judges. That role has not been sufficient.
Is this how this court operates? Because to me this looks like an assessment kind of process. If you come here to consult, consultation may be part of assessment. Yes. So do you go to all these states? Is this a way of doing your work, that you go to all these states? The way you're here in Kampala, will you be expected in Rwanda one day, Kenya the other day, like that?
Of course, this sounds and looks unusual for a court to get out and meet its potential users, telling them how and what to do. But exactly as you said, we are here on two missions. One, to get their feedback, and two, to sensitize them in different areas regarding our jurisdiction. We are starting with the Kampala in Uganda. As we speak now, the judges are in the conference going through the process. We started yesterday with the civil society whom we met. After here, we are meeting in September. We are going to Rwanda. We'll be meeting in Kigali, and thereafter Kenya, Tanzania, and Burundi. We are completing the circle, meeting all these stakeholders in 5 partner states.
Professor, have we registered some achievements in this court?
Oh yes, we have registered numerous achievements. When you look at even the number of cases we have had, it's very, very encouraging. So far, if I may refer to my list of cases we have had, since the court was established in 2005, rather 2001, we got our first case in 2005. Okay. In that first case, we have had ever since 130 cases received. But out of those 130 cases received, we are only 32 cases are not yet heard or determined. They are pending. Their hearing is ongoing, but we have not concluded. What does that mean? It means more than 102 cases have been determined between 2005 and 2012. That's one of the major achievements.
How equipped is this court? Because that looks like a backlog of cases. How equipped is this court in terms of human resource and all that?
Yeah, the court is equipped, but we are meeting challenges, as you are saying. Judges are not full-time. They only come to Arusha when there is business for them to transact.
Why is it like that?
Well, this is according to the treaty. Article 104 of the treaty says, in the interim, as a transition provision, the court will be meeting on a ad hoc basis until such time when the Council of Ministers sees that there is a need for the judges to be full-time. We are now mounting not a campaign approach of the Council of Ministers to see the need of having, especially the first instance court, to be full-time, because we have now enough business to justify their full-time.
Yes, because I was also going to ask you that in realization of a lot of work to do. Why don't you employ people permanently?
Yes, permanently. The rest of the court staff are permanent employees. But the judges only come to Arusha when there is business for them to transact. For the time being, we have introduced, like many other international courts, we have introduced the system of sessions. We have quarterly sessions, each session taking 30 days. And during that period, we handle the cases that are available. But we think it is still going to build on the backlog. That's why the plan is to have the judges of first instance, which generates business for appellate division, for them to be full-time in Arusha. For the time being, we have president of the court and the principal judge only full-time in Arusha, but that's not enough.
Now, this East African Court of Justice being permanently established in Arusha, isn't it expensive for some of us who would have issues to be brought to this court? We are in Uganda, we are in Rwanda, we are in Tanzania, we are in Kenya, those countries that, other countries that are not Tanzania. So, isn't it expensive? Why isn't this court operating in a rotative kind of way that the next month, for example, it sits in Arusha, today it's in Kampala, the other day will be in Nairobi, like that? Why isn't it like that?
Well, thank you for that very important question. And actually, I wish to take this opportunity to, of course, inform the public that the court has been mindful of that challenge. And we know Arusha is far from almost everybody.
Definitely.
Take, for example, a person in Kasese, at the borders of the countries, even wherever. So Arusha, is, much as it is a center, it is still far away from so many people. What we have just done in realization of this, the court has gone ahead to establish the major principle of bringing justice nearer to the people. Good. How do you bring justice nearer to the people? To start with, we have established sub-registries in every capital of the partner states. So we have a sub-registry here in the Supreme Court building, meaning with the East African employed staff who is there full-time. You don't have to travel to Arusha in order to file your case. You just go to the sub-registry, which is located in the Supreme Court building here in Kampala.
Much as the hearing will be in Arusha.
The hearing may not be in Arusha. It is again another principle that, as a matter of policy, what we are saying is, where parties come from the same place, the same area to start with, it is now the policy of the court to go to where the parties are, instead of the parties coming to the court in Arusha. We have done that. We had a session in Nairobi. We had a session in Dar es Salaam, and we expected to have one maybe in September in Burundi, in order to address your concern of being costly for people to travel to Arusha. And with our sub-registry, we think people will not have to travel, but again, when it comes to hearing of cases, people should not travel to Arusha.
I expect you to tell me what I'm going to ask you is the responsibility of the respective governments.
Yes.
But what has this court done to see that all the people in East Africa at least know about its existence? Because a cousin of mine in Kotido may not know about this court, but he would have an issue, a burning issue that would be handled effectively by this court. What have you done at least to know that people in the whole of East Africa really know about you? As a court?
Absolutely. Visibility of the court is still a challenge. It is not only the visibility and the knowledge of the people about the court, even about the community itself. But speaking now for the court, the court has realized this, and for a long time, for the first time, the court got out of the legal cocoon, where self-restraint attitudes would dominate it and say we cannot go out to meet the stakeholders because they are going to come tomorrow. We started doing that from 2005, after not seeing cases coming our way. That was one. This mission is the second, and another such initiatives which the court is taking. But as you know, the only way the court communicates is through judicial pronouncements. But the question is, how many people read judgments?
True.
So what we have been doing is to buy space in the newspapers to write about the court. And when you are writing about the court, you have to be careful. You don't have to assure a person that, oh, this case should be brought here. The following day, your assurance will be subject to litigation in the court. True. And you may be quoted. But what you want to reach out these people is to tell them, this court is there for you to save you. We are using opportunities like this one. When we visit countries, like when we visited Kampala, we got this opportunity. We thank very much UBC for according us this opportunity. And exactly this is what we normally do. We have radio, broadcast, at least to the extent that we can reach the people within our means.
Let them know about
the East African Court of Justice.
Now, I'll take you back to your being in Uganda.
Yes.
Yesterday you were meeting the judges.
Civil society. Today we are meeting the judges. Yes.
What is the content of these discussions that you are going around having in Kampala?
Yes, the content of our meetings, one, especially for civil societies, is to give them, and even the judges, give them feedback of how we have fared. What have we achieved? What are the challenges that we encountered in the course of getting what we call achievements? That's one. We go ahead to tell them as civil society, we have a presenter from the civil society organization to come and tell the court the attitude, the thinking of the civil society about the court and how it is handling. All these concerns like accessibility are issues that came out in the proceedings. We are going also ahead to tell them the benefits as a civil society arising from the common market protocol, because that common market protocols has freedoms and the rights. They have to be realized, and should, in the effort, in the process to realize those rights, they may be denied. Where do you go? It is now to the East African Court of Justice. And finally, which is very, very important for us, is amidst all these challenges, what is the way forward? We are proposing to them the strategies that we have. We want to send this court in 2 digits. Our relationship with the court, with the national courts, has been to the effect that now the judges are going through activities. How do they relate with the East African Court of Justice? Are they competing? The answer is no. They just complement each other. And now, to what extent will this complementarity concept be implemented?
So you are looking at all that.
All that.
What should East Africans expect? Just in a very brief statement as we wind up.
The East Africans should expect one thing: services reliable from independent East African Court of Justice. Whenever you have a matter affecting you, arising out of the treaty, and you think you are right, and this is unique. I may take a short of an opportunity. This is unique, where national and regional and international courts are normally not directly accessible. There are conditions. You either exhaust your local remedies or you pass through certain institution in order to go to the regional court. But for East African Court of Justice, the founding fathers of the community left it open. As long as you are a natural person, you are a legal person, in this case NGOs, and you think a treaty has been violated, it could be your rights or somebody's rights under the treaty, approach the East African Court of Justice. What we are assuring the people is a fair, independent decision will be given.
Professor, I would love to thank you.
Thank you so much.
Thank you so much for joining us and giving us some of your time in Kampala and giving us more enlightenment about the East African Court of Justice. That has been Professor Dr. John Eudes Ruhagisa, a registrar in the East African Court of Justice. Thank you so much for watching. I'll return with more stories. You're still watching UBC News Journal.
Transforming